Okay, so welcome back. So, as I had stated earlier, that we are going to do a session on insolvency regulations. We will extract key procedures, we will extract prediction questions from the regulation, and we have simplified the same for your understanding. The reason why I went for the insolvency regulation is because it will make reference to the act where a certain procedure is statutorily provided for. So basically, I started by saying that questions will start flowing directly from preliminary provision, because you cannot interpret a bankruptcy question if you don't understand what we mean by the prescribed bankruptcy level. So if you look at section 3, regulation 3 of the insolvency regulation, it says that for the purposes of the act, the prescribed bankruptcy level for all other bankruptcies is 250,000. So Kenyan courts have applied these regulations as a strict monetary getaway. A creditor's bankruptcy route under the Insolvency Act should not be invoked unless the liquidated or unsecured debt or aggregated debts is at least 250,000. Where the aggregate exceeds 250, courts generally treat the threshold as satisfied, and the court will move accordingly to apply Section 17 requirements, where we have service of demand, inability to pay, and no pending set aside applications, etc. So we can say where we can have aggregates that are beyond the 250,000 threshold, the same will still be adequate. So back to the presentation is that we have the governing rules. We have section 17(2)(a) of the Insolvency Act that lays the threshold for statutory angle once you have decided that you have noted of a bankruptcy level being arrived at. So judicial interpretation, when it comes to this part, we can see that the High Court rejected the argument that some individual claims fell below the threshold where the aggregate statutory demand exceeded the prescribed minimum. Regulation 3 is read together with Section 17(2)(a) on aggregate debts. The case is known as Invesco Assurance Company Limited versus Dama Charo Nzai 2019. So basically, I decided to highlight directly Section 17 so that we can get the grapevine of what amounts to the highly tested part when it comes to bankruptcy questions. So Section 17 provides for a creditor may apply for bankruptcy order in respect of a debtor. So one or more creditors of a debtor may make an application to the court for a bankruptcy order to be made in respect of the debtor in relation to a debt or debts owed by the debtor to the creditor or creditors. Such an application may be made in relation to a debt or debts owed by the debtor only if at the time the application is made. So these are the things that you need to have looked at. We started with the preliminary part. We look at the regulation number 3 that fixed the prescribed bankruptcy level. So we have taken note that it is above 250,000 or equivalent to 250,000. So we are safe. What are the critical angles to consider? The amount of the debt or the aggregate amounts of the debt is equal to or exceeds the prescribed bankruptcy level, that was 250,000. B. The debt or each of the debts is for a liquidated amount payable to the applicant creditor or one or more of the applicant creditors, either immediately or at some certain future time, and is unsecured. So we'll still have an analysis of this part on its own. So let us proceed to the next requirement. The debt or each of the debts is a debt that the debtor appears either to be unable to pay or to have no reasonable prospect of being able to pay. And now this means this part is being interpreted conjunctively, and there is no outstanding application to set aside a statutory demand in respect of the debt or any of the debts. So basically, before creditor makes an application for bankruptcy order in respect of a debtor, do you know the prescribed bankruptcy level, 250,000 or above. Now, do you know the threshold that you must understand pursuant to Section 17 of the Insolvency Act? Check the prescribed bankruptcy level. Check whether the debt is for a liquidated amount payable to the applicant creditor. Check whether the debt, whether the debtor appears either to be unable to pay or have no reasonable prospect of being able to pay. Then lastly, because these things are mandatory, make sure there is no outstanding application to set aside a statutory demand in respect of the debt or any of the debts. So another key takeaway principle that you must understand is that defects or overstatement don't automatically defeat the process if the debt still clears the threshold or can be cured. What do I mean? Courts have treated some defects in the demand, including misdescription, overstatement issues as curable or not fatal, where the data does not show substantial dispute or prejudice and the undisputed amount remains above the statutory level. Okay, so this is basically to tell you that if you ever encounter a situation where there is some defects in the demand, whether the parties have been misdescribed or there are some overstatement issues that have been made by the creditor who has done this application. So let that not confuse you. Provided the amount is undisputed by the debtor and it remains above the statutory level, this will not defeat this application. Principle number 3, once the threshold is met, court focus on Section 17 compliance and inability or no reasonable prospect to pay. What do I mean? Whether the court meets or when the debt meets or exceeds the prescribed level and the creditor proves proper statutory demand plus non-compliance, courts readily issue bankruptcy orders absent a substantial dispute or a counterclaim or set-off or credible payment or security proposals. That was a case of Diamond Hasham Laji versus Kajil Kenya Limited 2019. What are the synthesis and practical steps that you can deduce from this preliminary point? Plead the threshold explicitly. Cite Section 17(2)(a) and Regulation 3. Okay, and state the exact liquidated or unsecured amount and show it is above 250 or equivalent to 250,000. If relying on multiple debts, plead and prove the aggregate meets the threshold. Breakdown plus provide the totals before the examiner. 3. If the debtor attacks the demand for overstatement or defects, isolate the undisputed minimum and show it still exceeds 250,000. Then argue the defect is not fatal or is curable unless substantial dispute or prejudice is shown. So if an examiner tries to mix up some defects that were made when you are serving this statutory demand, you extract the undisputed minimum and tell the examiner that still the undisputed minimum is falling pursuant to the prescribed bankruptcy level. 4. If debt is below 250,000, the creditor bankruptcy petition should fail at the gateway. Use ordinary civil enforcement or other insolvency alternatives if applicable, but not bankruptcy. Okay, so whenever you encounter a situation where the amount is not above 250,000, go try other forms of recovery. Then another rule that I found to be highly tested was on authentication of documents. Rule 5. Okay, how do courts interpret this rule? Regulation 5 is a minimum validity rule. It tells you when an insolvency document counts as properly attributable to the sender electronically or properly executed through hard copy. Practically, it is used to defeat objections that an insolvency notice or petition or response is invalid solely because it was sent electronically or because the signer did not disclose capacity. What are the governing rules that a student ought to master? Electronic documents. Adequate authentication is satisfied if 1. The recipient had specified an identity confirmation method and the sender meets it, or 2. If no method was specified, the communication states the sender's identity and the recipient had no reason to doubt it. Regulation 5 all the way from 1A to B of the insolvency regulations. So if the recipient had specified an identity confirmation method and the seller meets it, then you will have been adequately served through electronic means. Print documents. Adequate authentication is satisfied if the document is signed. If the document is signed, Regulation 5.2. Signing for other situation. Where signed by an individual on behalf of a body of persons, the document must also state the individual's position. If signed for a one-member company, it must state that fact. Regulation 5 all the way from 1 to B. Note that Regulation 5 duplicates Regulation 2 to 3 following amendments or drafting duplication, not a new rule. Let us look at judicial interpretation on how the governing rules have been interpreted so that we understand it clearly. So Kenyan insolvency decisions tend to treat form and authentication issues through a mandatory versus curable lens. The cases below are not Regulation 5 specific holdings, but they show the court's approach to formal validity of insolvency documents where it involves signature, endorsement, and capacity. Strict compliance where the form goes to competence. Where a statutory demand or petition is not executed as required by the regulations and prescribed forms, courts strike it out as incompetent. This is not a mere technicality angle that a student ought to know. So when you have been told to draft a statutory demand or a petition, failure to sign, maybe you will be losing all the marks provided in that question. Pan Africa Chemicals Limited versus Joanco Limited, 2024, a recent decision. Ratio decidendi. The court held that the statutory demand forming the basis of the liquidation petition was invalid because it was signed by the deputy registrar rather than the creditor or an authorized person. So be keen on that. Who signs a statutory demand? Who's supposed to sign? It is the creditor or an authorized person of the creditor, not by the deputy registrar. Regulation 77B2 and Form 32E require the statutory demand to be signed by the creditor and only endorsed by the deputy registrar. The absence of a valid signature by the creditor is a substantive defect, not a mere technicality, as it undermines the foundation of the insolvency proceedings. Consequently, the petition was incompetent and incurably defective, warranting its striking out. So if in practice people's suits are being struck out, people's petitions are being struck out for want of a signature, who are you not to incorporate a signature when you are drafting this petition? Okay. East African Cables versus Trans Africa Energy Limited, 2022. Ratio decidendi. The court found that the statutory demand served by the applicant was not signed by the creditor or an authorized person, but by the deputy registrar, who had no authority to issue or sign the demand on behalf of the creditor. Section 384(1) of the Insolvency Act requires that a statutory demand be issued and signed by the creditor. The court relied on both statutory interpretation and prior case law to conclude that the statutory demand was invalid. As a result, the petition for liquidation, which was premised on this invalid statutory demand, was incompetent and could not be sustained. The court therefore struck out the petition with cost, holding that an invalid statutory demand cannot be foundation for a liquidation petition. Another principle that a student ought to take note of: process defects can be fatal when they undermine the statutory scheme, e.g., using the wrong insolvency track and non-compliance with prescribed conditions. Victoria Advertising Limited versus Property Reality Limited, 2025, a recent decision. Ratio decidendi. The court found that the statutory demand and the liquidation petition were both incompetent in form and substance because they failed to comply with the mandatory requirements of the Insolvency Act and regulations. Specifically, the statutory demand was not endorsed by the deputy registrar as was required, and the proceedings were improperly amalgamated bankruptcy and liquidation processes, which are distinct under the law. The court emphasized that statutory demands and petitions must strictly adhere to the prescribed forms and procedures, and that safeguards in insolvency law are designed to protect both debtors and creditors by ensuring due process. As a result, the application to set aside the statutory demand and strike out the petition was allowed, with directions that the petitioner must comply with the relevant provisions and file separate proceedings as required by law. So we can say that this was an advocate who had duly certified the board CLE examiners and went ahead to draft two conflicting procedures. He used the wrong prescribed formats and procedures, and the same were met with the equal force that they deserved. So allow me to check whether the recording is having a voice, to avoid a situation where I had recorded without a voice, so it is okay. So what are the synthesis and practical steps on how to apply Regulation 5 questions? If you are serving or filing by email or electronic form, take note of the following. If the recipient, court registry, official receiver, other party has a stated method, e-filing, portal login, specific email, reference number, OTP, comply with that method exactly. Regulation 5(1)(a). If no method is specified, ensure the email or attachment clearly states the sender's identity, name, firm, party, contacts, and keep proof showing there was no reason to doubt identity. Official email domain, prior correspondence chain, callback confirmation, Regulation 5(1)(b). You can also attach a receiver's receipt of the email. If you are executing a hard copy document, make sure it is signed on wet signature. Regulation 5(2). If signing on behalf of an entity, add the signer's capacity, e.g. the director, company secretary, partner, trustee, advocate for, on the face of the document. Regulation 5(3)(a). If the signer acts for a single member company, state it clearly on the document. Then, other part that I saw relevant when it came to application questions was part 2 of the regulations, publication of notices. What does it entail? How have courts interpreted this part? So Regulation 6 all the way to 9 set a mandatory minimum content standard for gazette notices in insolvency matters. The notice must identify the proceeding and the office holder and must contain enough particulars to let creditors and the public reliably identify the debtor or company and participate. Court treat publication where required as substantive, and missing core particulars can expose the process to strikeout and adjournment directions. What are the governing rules? Where gazette publication is required, the notice must include Part 2 details plus any extra details required elsewhere in the Act or regulation. Omission carve-out. A required item may be omitted only if it is reasonably practicable to obtain it. Universal notice context. Where applicable, identify the office holder and state contact details, insolvency practitioner number, except official receiver, because official receivers are appointed by court, alternative contact person, and appointment date, plus court, file, case number, or adjudicator, a reference. Okay, so that is the universal context of how a gazette notice should be described. Office holder and their details. So basically you are describing a person to the ultimate satisfaction of the examiner. Company notices must state the company name, registered office, principal trading address, prior registered names in the last 12 months, and any trading style under which it carried on business or incurred the debt, and registered companies, if they exist, identify the business and styles. That is provided for under Regulation 8. Bankruptcy notices for natural persons must identify the bankrupt and give last 12 months residential addresses, principal trading address, date of birth, occupation, aliases, and any business name or style under which debts were incurred. So basically the examiner is telling you that for gazette notices, the gazette notices must be duly described. Where aliases involved, where there is a change of name, give the name accordingly prior to the last 12 months for you to change the name. Okay. Another thing that you need to take note of is that Part 3 of the insolvency regulations, it says that this regulation applies to applications made in court pursuant to the provisions of the Act, but does not apply to an application for an administration order, a winding up petition, or a bankruptcy petition. Okay, so these applications that are being brought pursuant to Part 3 shall be made pursuant to a notice of motion. Look at what I have outlined in red. The application shall be signed by the applicant or the applicant's advocate, mandatory. Then it shall be by notice of motion, but it shall not apply to an application for administration order, a winding up petition, or a bankruptcy petition, because that is a separate application to make. And this application shall state, pursuant to the provisions of the Act, the section that the application is made to, the names of the parties, name of the bankrupt or the company, the court where applicable, where the court had allocated a number, you state the nature of the remedy and the names and addresses of the persons to whom it is intended to be served upon. Part 4 of the insolvency regulations talks on insolvency practitioners. Now we have started delving into some key identifiers that confuse students. We will read part 4 in verbatim. Academic requirements for insolvency practitioners. For purposes of Section 6(1) of the Insolvency Act, a person is qualified as an insolvency practitioner if that person, 1, holds a degree from a university recognized in Kenya, 2, has at least 5 years relevant professional experience as a member of a professional body recognized under Section 7 of the Act. Okay, I went to Section 7 of the Act and found that Section 7 of the Act are professional bodies that will be duly gazetted. Okay, we will have a look when we will be analyzing the Act itself. So don't expect that you will find a list of professional bodies so that you will go counter-checking in the examination paper whether this body amounts to the one that has been duly gazetted in that part. No. Provided you have been told that this person is a member of a professional body, okay, recognized. So we'll have, maybe Albert, you can assist me by reading in verbatim Section 7 of the Act so that we'll be clear. Can a question be brought specifically for to test where a person is not forming part of a professional body recognized under Section 7? I'll greatly appreciate, because you will realize that this test is to be read in a conjunctive manner. It is a test that you must satisfy each of the brackets. So failure to understand the professional bodies recognized under Section 7 can lead you into trouble. So I believe, Albert, you are confirming the same as I continue. Albert, are you in a position? Let me look.
Yes.
Okay, you can read it out verbatim, Section 7 of the Insolvency Act, so that we don't miss a crucial exception provided in Section 7 of the Act.
Okay. Section 7 of the Insolvency Act provides for duty of Cabinet Secretary to declare certain bodies to be recognized as professional bodies for the purpose of this Act. Clause 1. The Cabinet Secretary shall, by notice published in the Gazette, declare one or more professional bodies to be recognized professional bodies for the purpose of this Act. 2. The Cabinet Secretary may declare a professional body to be a recognized professional body only if it regulates the practice of our profession, and B, maintains and enforces rules authorizing its members to act as insolvency practitioners to ensure that members 1. Are fit and proper persons to act as insolvency practitioners. And 2, meet acceptable requirements relating to education, practical training, and experience. 3. Clause 3. A reference to the members of a recognized professional body includes a reference to persons who are, whether members of that body or not, governed by its rules in the practice of the relevant profession. Clause 4. The Cabinet Secretary may revoke a notice made under subsection 1 if it appears to the Cabinet Secretary that the professional body no longer meets the requirements of subsection 2. 5. A notice made by the Cabinet Secretary under this section takes effect from the date of the notice or such other dates as is specified in it. Clause 6. The Cabinet Secretary may, in revoking a notice of Section 1, exempt a specified member or a specified class of members of their professional body concerned from the effect of the revocation, and to authorize the member or members of that class to continue acting as insolvency practitioner or as insolvency practitioner for such period as the Cabinet Secretary determines and notifies in writing to the member or members concerned. Clause 7. In this section, profession means a profession involving carrying on any activities referred to in section 4.1 or 2. That is the end.
Yes, section 4.1 and 2, because it looks that it is the one that is describing the professional angle of it.
Yes. Section 4.2, it provides for the insolvency practitioners and circumstances in which person acts as insolvency practitioner.
Thank you, Albert. So a key takeaway. So we can say that there is no professional body list that is recognized under Section 7, but the powers are reserved by the Cabinet Secretary to make a notice. Albert, is that the takeaway?
Yes, true. I also agree. So long as there is no express list of professional bodies that have been mentioned,
yes,
only the licensed or qualified insolvency practitioners are contemplated under the meaning of Section 7.
Thank you, Albert. So we can take the second test to say that if that fact that has been provided by the examiner tells us that a certain person is a member of a certain professional body and he has at least 5 years of relevant professional experience, then we will tick that box as have been duly complied with. C, has at least 2 years experience in insolvency practice before commencement of the act. At least 2 years experience in insolvency practice before commencement of the act. D, has worked under the apprenticeship of an insolvency practitioner for at least 4 years and satisfies the requirements of Chapter 6 of the Constitution. So if you read that part only in itself, it is mandatory. So key takeaways: do you have a degree? Do you have 5 years in a relevant professional membership body? Have you practiced? Do you have experience before commencement of the Insolvency Act? When did it commence? Was it in 2016? The Insolvency Act, Albert, maybe because you are the one who has opened the Act, you can tell us the commencement date. So that commenced on 24th March 2016. These are the regulations. So you can confirm the exact year when the Insolvency Act came into the picture, so that we will be deducing those facts from the question. So let us continue ticking the box. Do you have a degree? Professional member, 5 years. 2 years. before the act.
So the commencement date, I think it's 27th June 2016.
Okay, 27th June 2016. So if the examiner brings that a person only practiced in 2015, then they are not eligible to be qualified as insolvency practitioner. But we will have a look at how the courts have interpreted this test when we are analyzing now the Insolvency Act on its own. Okay, because I saw a question where people who had practiced at least 2 years before the commencement of this act were saved by a saving clause inside the Insolvency Act that had allowed for persons with 2 years experience before commencement of the act. So it is not to be applicable to people who found the act in existence. So those people will be tested with the other requirements. Have you worked under the apprenticeship, under this guidance of an insolvency practitioner for at least 4 years? Because if you have practiced under the supervision of an insolvency practitioner for at least 4 years, then we can say you have gained the experience as equivalent to a person who had practiced before the commencement of the act. And do you satisfy the requirements of Chapter 6 of the Constitution of Kenya? 2. An advocate, so this is to be read in seclusion, an advocate who has worked for the official receiver for not less than 2 years automatically qualifies to act as an insolvency practitioner. Many students are saying that it is any advocate. Okay, remember the insolvency regulations are clear. An advocate who has solely worked for the official receiver for not less than 2 years, you automatically qualify to act as an insolvency practitioner. 3. The official receiver may waive the requirements set out under sub-regulation 1A. 1A, the one who holds a degree from a university recognized in Kenya. The official receiver has powers to waive the requirements set out in that regulation, where the applicant has practiced insolvency for at least 10 years prior to the enactment, prior to the commencement of the Insolvency Act in 2016. Another angle that an examiner can use to confuse a student. You can be told that a person has practiced insolvency for at least, for more than, in fact 11 years. But this person does not hold a degree from a university recognized in Kenya. The official receiver may waive that requirement in his own capacity. The official receiver shall, within 30 days of the decision made above, shall communicate such waiver to the applicant in writing. So, however a question comes, because an examiner will likely test these situations in a problem situation where a person had also appointed an insolvency practitioner, and the only angle you can attack this procedure is looking at the qualifications of the insolvency practitioner who was handling this matter. So those are the tests. An advocate, not see any advocate. Have you worked for the official receiver for not less than 2 years? So for more than 2 years. Higher. Have you observed a degree from a university recognized in Kenya? If no, have you practiced for more than 10 years? Okay, official receiver, you have the power. Have you met the at least 2 years experience before commencement? Have you worked for at least 4 years? If you found the act in place, do you certify Chapter 6 of the Constitution of Kenya? Are you in a relevant professional experience as a member of a professional body? Common mistakes that students make. Treating the list as alternatives instead of cumulative. They treat as alternatives. It is a mandatory procedure. 2. Missing the pre-commencement timing requirement. Many candidates assume 2 years insolvency experience can be gained now. The text requires 2 years before commencement, a transitional condition. Confusing apprenticeship with general work experience. Apprenticeship is supervised practice under an insolvency practitioner, documentable mentorship, not just worked in a law firm or bank. Do you have documents to prove? Assuming the official receiver can waiver anything. Regulation 11.3 allows waiver only of the degree requirement, not the 5-year professional body experience, not the apprenticeship, not Chapter 6. Overriding Rule 11.2 automatic qualifies as exempting Chapter 6. Automatically qualifies removes the need to prove Regulation 11.1a to d track, but does not plausibly override constitutional Chapter 6 requirement for state-regulated professional roles. Okay, so we will go back. Kuna kitu I've noticed. Not tying Regulation 11.1b to professional body recognized under Section 7 of the Act. Students cite any association. The regulation requires a body that the Act recognizes. Okay, before this concept evaporates, an advocate who has acted for the official receiver for not less than 2 years automatically qualifies to act as an insolvency practitioner, but it is not exempting Chapter 6 requirement. If the advocate is suspended for that period that is making this application, then he will not be considered to act. Do you meet Chapter 6? Another thing that I've noted, and I may have overlooked it, is it a must that if you do not automatically qualify, there are 18 insolvency practitioners in Kenya. Could it be due to the fact that you require at least 2 years experience in insolvency practice before commencement of the Act in 2016? Is it mandatory for everyone? How do courts interpret at least 2 years experience in insolvency practice before commencement of the Act? That question will be answered when we will have the other session when it comes to insolvency regulations or insolvency act. We will begin with that. Is it a gatekeeping provision to make sure that no one else will ever qualify? Because if automatically I qualify maybe for this year under the at least 4 years, I have well documented materials to show that it was not a mere working experience, it was real supervision. Am I allowed to make an application? Am I being forced to work under the official receiver first so that I can automatically qualify? Those are the questions that arise from Part 4. Exceptions. What actually relaxes the rule? Official receiver advocate track. If you are an advocate and have worked for official receiver for more than 2 years, you automatically qualify. You don't need to prove the Regulation 11.1 all the way to D pathway. Degree waiver only. Regulation 11.3. If you have more than 10 years insolvency practice pre-commencement of the Act, the official receiver may waiver only the degree requirement and must notify in writing within 30 days. Okay. Procedure for application of license to act as an insolvency practitioner. You have been informed to duly advise a party who wants to make an application to be appointed as an insolvency practitioner. So Regulation 12 creates a step-by-step licensing pipeline controlled by the official receiver. Apply through Form 1 plus pay the prescribed fees. Sit the official receiver's professional examination fees, exam plus pay the fees to the exam. Then the decision will be made within 30 days. If accepted, obtain professional indemnity insurance cover and lodge security by bond amounts in the second schedule. The other angle is that authorization certificate is issued and published under the Kenyan Gazette plus wider circulation newspaper and official receiver's website. So as a brief overview so that you can have this procedure at your fingertip. 1. You make the application. This application is made to the official receiver under Insolvency Act Section 8 by submitting a duly completed Form 1, and you pay the prescribed fees. Pass on to the second step. The application must be accompanied by the prescribed application fee provided in the second schedule. 3. Examination. After you have made the application, you have paid the fees, you sit for an examination. After receipt, verification and acceptance of the form number 1, the applicant must sit a professional examination administered by the official receiver at the prescribed fee. So you need to pay for the examinations. Then 4. Decision timeline and reasons. Upon receipt of the fees, the official receiver must communicate acceptance or refusal within 30 days, and if refusing, must give reasons. Okay. Post-acceptance requirements is, if accepted, the applicant must obtain professional indemnity insurance cover and deposit security by enacting bond to secure proper performance. Okay, so let's say you have been admitted, immediately take out a professional indemnity insurance cover, then deposit security by enacting bond to secure proper performance. 6. Amounts. The professional indemnity insurance cover and bond amounts are as set out in the second schedule. Then 7. Issuance and publication. Once the insurance cover and bond are lodged, in fact, we can say that the insurance cover and the bond security are mandatory, because you have to lodge the same. Then the official receiver issues the authorization certificate and publishes the authorization in the Kenya Gazette, at least in one newspaper of nationwide circulation, and on the official receiver's website. So those are the things that many students will not be keen to note, that it is mandatory. Okay. Part 5 of the insolvency regulations on personal bankruptcy. A creditor may apply for bankruptcy order in respect of debtor. For the purposes of Section 17 of the Act, of which we have duly discussed, the procedure for complying with or setting aside a demand is as provided under Regulation 16 and 17. Okay, we'll have a look at the procedure now, where you have been told to set aside a certain statutory demand because the statutory demand was not signed by the creditor, but the question has told you that the statutory demand was signed by the deputy registrar. So you will have to advise this party to make an application. And what rules will you draft? Regulation 16 and 17, of which we have duly drafted. Higher. The creditor's application for bankruptcy order shall be in form of a petition in form number 3, set out in the first schedule, and shall be accompanied by the following documents. So now a creditor wants to make this application for bankruptcy order against a debtor. This is provided for under Regulation 15. What are the documents that you need to draft? A petition, Form 3. Verifying affidavit, Form 4. Proof of debt, which shall be in Form 5. An application for appointment of trustee, which shall be in Form 9. Okay, we have seen decisions where an advocate used wrong forms. So that is not a technicality, that is ignorance of the statutory provided forms. Petition Form 3, in fact, they are flowing. You draft a petition. What do you use to support the petition? A verifying affidavit. Have you annexed proof of debt? Because you cannot be given a bankruptcy order if we cannot see that there is proof of debt. Form 5. So Form 3, 4, 5. Then Form 9. An application for appointment of trustee, which shall be Form 9. Okay. Then the petition, luckily we have drafted. We have done a substantive work on it. The petition shall be preceded by a statutory demand and shall be in Form 6 set out in the first schedule. This student, before drafting this petition, was he aware that a statutory demand was never issued? Was he aware that statutory demand was never signed by the creditor? The statutory demand in Sub-Regulation 3 shall be endorsed by the Deputy Registrar of the High Court before it is served on the debtor. Okay, at what point do you have this endorsement? Okay, you have drafted. First take it for endorsement, then take it for signature to the data, not vice versa. The statutory demand specified in Subregulation 3 shall be served on the debtor at least 21 days before the filing of the petition. You are a student. Why are you drafting a petition before the lapse of 21 days? Okay, those are the nitty-gritties. The service of the statutory demand shall be in accordance with the civil procedure rules. If you are a good student, of which we have analyzed civil procedure rules, order by order, drafting any possible application. We have not ignored any order. We have drafted. We will have an overview of it. If you are a good student of civil procedure rules and you duly master all the procedures when it comes to service, even service outside the Kenyan jurisdiction, okay, do you know the exceptions of service outside the Kenyan jurisdiction? Okay, what have courts said when it comes to service outside the Kenyan jurisdiction? Maybe it is a creditor's bank, it is a bank outside the Kenyan jurisdiction. What are the nitty-gritties? We will look at the rules of service upon a company, upon an entity, upon an individual person and a foreigner. Regulation 15 is the mandatory pre-filing checklist for a creditor's bankruptcy petition against a natural person. You must, 1, serve an endorsed statutory demand provided in Form 6 of the Insolvency Regulations. You have to wait for at least 21 days after service. Then file the creditor's petition form number 3, with the 3 companion documents: verifying affidavit form 4, proof of debt form 5, and application to appoint a trustee form 9. Non-compliance, especially lack of deputy registrar endorsement or premature filing, can render the demand of petition incompetent. A student can take the statutory demand directly to the debtor for signature without first knowing that you need to pass through the deputy registrar for endorsement first. Governing rules. Creditor's right plus statutory preconditions. Section 17 Insolvency Act. Debt must meet prescribed level. Okay, in fact, even before serving the endorsed statutory demand, did you ask yourself, have I met Regulation 3 of the Insolvency Regulations? Is it above 250,000? It is challenging a certain amount. Okay, I have removed that amount. The minimum amount, this is the total, is still above the minimum prescribed level. So you are okay. The debt must be liquidated or unsecured. Okay? Debtor unable or no reasonable prospect. If the debt is secured, what happens? So those are the questions that we will keep answering when time goes on. Debtor is unable to pay, or there is no reasonable prospect of him being able to pay. No pending set aside application is in existence. We saw a student who was capable of ticking the boxes when it comes to the Section 17 of the Insolvency Act requirements, because they were told to state the requirements that, 1, that the creditor ought to take note of before filing a petition. Okay, so Regulation 15 of the Insolvency Regulations. Set aside compliance procedure, Section 16 to 17. Petition must be in Form 3, 4, 5, 9, even in that order. Petition must be preceded by a statutory demand, Form 6. Form 6 must be endorsed by the Deputy Registrar before service. Serve at least 21 days before filing petition. Service must comply with civil procedure rules. Judicial interpretation. Deputy Registrar endorsement is mandatory. Lack of it can seek the process. The court set aside a statutory demand and struck out a petition where the demand was not endorsed and the proceedings mixed distinct insolvency tracks. Okay, 21 days is counted from service. Application to set aside must be within that period. Hapa sasa ni moto. When do you count the 21 days? You count from service. And application to set aside this statutory demand must be within the 21 days period. Okay, so examiner hapa anakuweka as a creditor, alafu pia in any case anaweza kushift to be the debtor. 21 days, are you within the timeline? Good. File the application to set aside. If the creditor proves proper service and compliance with regulation, with section 17 of the Insolvency Act and regulation 15, the court will grant the bankruptcy order unless the debt is genuinely disputed or other statutory bars apply. Overview. Prepare statutory demand. Before that, check prescribed minimum level. Then prepare statutory demand form 6. Present form 6 to the High Court Deputy Registrar for endorsement. This is mandatory before service. Rule 15. Serve form 6 on the debtor in accordance with the civil procedure rules. Personal service unless substituted service is permitted or ordered. For substituted service, you must seek the directions of the court. You must seek the permission of the court for substituted service. Wait at least 21 days after service and confirm there is no pending application to set aside the demand. Okay? If no compliance or no set aside, file the creditor's petition package. Package Form 3, petition. Form 4, verifying affidavit. Form 5, proof of debt. Form 9, application for appointment of trustee, plus affidavits of service of the statutory demand, copies of judgment, decree, contracts, computation of interest, and proof of debt meets the prescribed level. That is theory. Do you know how to draft it? Now a question tells you, kindly draft the appropriate documents to help salvage the situation. How do you draft a statutory demand? Form 6 is outlined as shown before you. Republic of Kenya, in the High Court of Kenya, jurisdiction is a mark. The Insolvency Act, in the Insolvency Cause Number, in the matter of debtor, this statutory demand, enabling provision, regulation 15, form 6. You can just write form 6. To debtor, full name of the debtor, physical address. What did he say? Every notice should, any demand should clearly describe the last known place or the physical address or the postal address of the person you are going to serve this document. Take notice, it's a demand, it's a statutory demand. Take notice that within 21 days, have you captured the timelines so that if you want to respond, you can do so within the 21 days. Failure to incorporate the days, then it means your statutory demand is fatal. That within 21 days after service of this notice on you, excluding the day of service, you shall pay to the creditor full name, address is this, or agent kama an advocate of this or this, pay this amount, being the amount due arising from judgment, decree, in case number delivered on this contract. You can also find attach, endorse before endorsement, or you must secure or compound for the said sum to the satisfaction of the creditor or to the satisfaction of the court, or satisfy the court that you have a counterclaim set off or cross demand against the creditor. So those are the various options you are telling the person to whom you are serving that they can do so, maybe to expedite the process. Further, take notice that failure to comply will entitle the creditor to present a bankruptcy petition against your estate. The same way we have been told to draft a demand letter, we further take notice. You have the breach clause. The breach clause will also apply to the statutory demand. Failure to apply, what will you do? A bankruptcy petition. Is it dated? Is it endorsed? Who endorses? Deputy Registrar. When was it endorsed? On this date. Is it signed by the debtor? Those are the marking points. Now, you have duly satisfied the statutory demand. You have waited for the lapse of 21 days. Kindly draft a petition. Same title. You are allowed to make reference to the title used in my statutory demand to save on time. But the form must be independent. Creditor's petition, Form 3, pursuant to Regulation 15(2). I or we, because sometimes creditors can be many. I or we of our address, this and this, petition the court for bankruptcy order against this person. Explain and state. 1. The debtor has within 1 year preceding this petition resided or carried on business within the jurisdiction of this court at this address. Why are we incorporating this provision? Because we said that Any creditor's petition must disclose the last known address or residential address or carrying business premises of a debtor. The debtor is indebted to me in the sum of this amount. Particulars annexed. The debt is unsecured, or if secured, state security and estimated value. This now answers the question that I asked you earlier. Section 17 provides for liquidated debts or unsecured debts. But what if it is a debt that it is secured? You can still bring the creditor's petition provided you state the security and estimated value of the security. 4. The amount owed meets or exceeds the prescribed bankruptcy level and satisfies the requirements of Section 17 of the Insolvency Act. Okay? But the examiner will want to see you applying the requirements of Section 17 of the Insolvency Act in this creditor's petition. So you cannot directly refer an examiner to Section 17. Those are marks that you are impeding yourself. So the debtor is unable. So no, I have now listed. The debtor is unable or has no reasonable prospect of being able to pay the debt. There is no outstanding application to set aside the statutory demand. 7. At least 21 days have lapsed since service of the statutory demand endorsed by the Deputy Registrar on this date, and the debtor has neither complied nor set it aside. You can also add, I also served the statutory demand on this date upon the debtor and is duly signed on this date. So many students will cram the form and the format, but when they are being told to apply their theory to drafting, that is where they draw the line. Because in our position, we know what to incorporate, we know where to get these minimum requirements. So that is the structure. What are the prayers? Prayers. I pray for a bankruptcy order being issued against the debtor's estate. I pray for a trustee to be appointed as per the accompanying application. Cost be provided for. Okay. Signed. Who signs? The creditor. Dated. Form 4. Remember it is a flowing form. Form 3, Form 4. Nona title nilisema as captured in the petition. Captured in the statutory demand. Form 4. Name. I, the petitioner above, make oath that and the petitioner retaliation of the particulars above. You now can bring the annexures, you mark them accordingly. Proof of service, do you have affidavit of service, proof of debt documents, because we saw proof of debt document was mandatory, so attach the mandatory document. Attach the copy of endorsed statutory demand, Form 6. Examiner will just look, hey, have you annexed? Have you annexed? In fact, maybe this is the marking scheme as compared to many stories. Have you annexed? Good, marks. Proof of debt, Form 5, a flowing 3, 4, 5. Proof of debt. How is it structured? Proof of debt, Form 5. Estate, if known. Debtor, full name. Creditor, this one. Amount owed is this. Basis of debt, because there's a judgment or a decree, order, there's a contract, there's an invoice. Security. Why security? Maybe it was a secured debt described. Supporting documents. Have you attached the decree? Have you attached the certificate of cost? Statement of account, invoices, good. Signed. Have you signed? What is the capacity of you who is signing this proof of debt? I'm the creditor. Good. Application for appointment of trustee. How is this drafted? Form 9. I, creditor of this, apply that the court appoint. You can also propose a trustee name, if any, of this address as trustee of the bankrupt estate, or in the alternative, the official receiver or a nominee of the official receiver. Okay, so key takeaways: creditor is making this application. Okay, to whom? To the court. In support of what? His creditor's application. Against who? The debtor. Okay, this is mandatory. What are you seeking before court? A creditor's petition has been filed against the debtor. it is necessary to appoint a fit and proper trustee to protect and realize the estate for the creditors. So, who is this trustee? So, it is a trustee of the bankrupt's estate, or the alternative, an official receiver, or a nominee of the official receiver. Full stop. You have the full marks. Mistakes and practitioners. Mistakes that students and practitioners make that get matters struck out. 1. Serving an unendorsed statutory demand. No deputy registrar endorsement. Fatal risk. Filing the petition before 21 clear days lapse after service. Regulation 15.5. Using the wrong form or mixing company liquidation forms with personal bankruptcy forms, and I believe that this also is applicable to our examination setups. Failing to attach the mandatory companion documents. A student will only draft a petition. Did you draft a statutory demand that was served? Have you drafted a petition, a verifying affidavit? Have you annexed some documents? Have you drafted a proof of debt? Form 5. Have you drafted Form 9? Appointment of a trustee. Those are the marks. Kama swali ni 10 marks, uko na zote. Bad service, no affidavit of service. Service not compliant with civil procedure rules. Serving wrong address or person. Trying to use bankruptcy to pressure payment where the debt is genuinely disputed, or invite set aside under Regulation 1617 or dismissal. No. Did that fact tell you that in your statutory demand, you can actually propose to this person to compute the debt that he thinks that he duly owes you because you have evidence to the contrary? Okay? Did you disclose to him? Did you serve him so that he does the procedure, the application to set aside under Regulation 16 and 17? Not proving the Section 17 gateways. Many students will never prove the minimum threshold, prescribed level, liquidated, unsecured. If secured, do you attach the value of the security, inability, or no reasonable prospect? Okay? No pending set aside application that has been duly served, that has been duly filed. Okay? So those are the nitty-gritties that you ought to take note of. So as I respond to something here, you can be reading the next Regulation 16, application to set aside statutory demand. Now this is another question you can be asked. Application to set aside a statutory demand. The data. Now, on the creditor side, we are perfect. On the debtor side, we don't know anything. An application to set aside a statutory demand. The debtor may apply to the court for an order to set aside the statutory demand within 21 days from the date of service on the data of the statutory demand, or if the demand has been advertised in a newspaper from the date of the advertisement's appearance or its first appearance, whichever is the earlier. So, it is not necessarily that you receive the statutory demand from the creditor himself. He could have opted to seek permission of the court to use substituted service, and maybe use the advertisement, general newspaper or nationwide circulation, and you see your name there. That is sufficient. Now, subject to any order of the court under Regulation 17.7, time limited for compliance with the statutory demand shall cease to run from the date on which the application is lodged with the court. The debtor's application shall be in Form 7 set out in the first schedule and shall be supported by an affidavit which shall be in Form 8 set out in the first schedule. Okay? So we can see that there is a prescribed form that allows a debtor to bring this application. Okay? And when you are bringing this application, allow me to respond to something. Just a minute, as you digest that part. So we can say that the debtor's application shall be in Form 7 that has been set out in the first schedule, and shall be supported by an affidavit which shall be in Form 8 set out in the first schedule. The affidavit referred to under paragraph 3 shall 1. Specify the date on which the statutory demand came into the debtor's possession. B. State the grounds on which the debtor claims that it should be set aside. Okay, so state the grounds and annex a copy of the statutory demand. What are these Form 7 have I drafted? Form 8. Okay, I've duly drafted the same application to set aside, yes. Okay. Hearing of application to set aside statutory demand. Okay. On receipt of an application under Regulation 16, the court may, if satisfied that no sufficient cause is shown for granting the statutory demand, dismiss the application without giving notice to the creditor. So, under what conditions will the court grant the application if the following happens? If the debtor appears to have a counterclaim, so the court may grant the application if the debtor appears to have a counterclaim, a set-off or cross-demand which equals or exceeds the amount of the debt or debts specified in the statutory demand. B. The debt is disputed on grounds which appear to the court to be substantial. C. It appears that the creditor holds some security in respect of the debt claimed by the demand, and either paragraph 6 is not complied with in respect of the demand, or the court is satisfied that the value of the security equals or exceeds the full amount of the debt. D. The court is satisfied on other grounds that the demand ought to be set aside. Okay? So those are the angles or the grounds that a debtor can coin in his application so that it captures the attention of the court, because the court may grant that application if the following is proved. Okay? This is the interpretation and the drafting part. To challenge a creditor's statutory demand, Form 6, the debtor must file Form 7. This form is an application to set aside the statutory demand, and this form is supported by Form 8 being a supporting affidavit within 21 days of service, or if the demand was advertised within 21 days of the first advertisement, and rely on one or more of the statutory grounds in Regulation 17.6. Okay, you can rely on one or more because they are conjunctive. Counterclaim, set-off, substantial dispute, security issues, or other grounds. Governing rules. Time limit. Take note of Form 7 and Form 8. Affidavit contents. State date of the demand that came into your possession. State the grounds that you are making this application. Annex the demand. So that is what the marking scheme will read. Has the student duly drafted the application to set aside statutory demand? Yes. Can you have a look at his supporting affidavit? Okay, this is the supporting affidavit, but it has a lot of stories. You say you may just have 3 pages. In these 3 pages, anaandika pale seen with 0 marks. Why? You never said the mandatory contents of the supporting affidavit. When did you receive this statutory demand? I received this date, or I saw in a notice, gazette hivi. These are my grounds. Where did you find this ground? I'm relying on section 17, a mandatory procedure. Done. Have you annexed the demand, the statutory demand that you were served? You unasema it came into your possession. Can you clearly see it? Is it endorsed? Is it signed? Unaona? Good. You obtain your full marks without stories. Regulation 17, hearing procedure and the grounds for setting aside. Regulation 17, 6A to D. Court may also order amendments where security is undervalued. If dismissed, court authorizes creditor to file petition. Remember in CLE, I don't want us to take an angle that you are sitting as a judge. If you are keen, when I realize something is administrative, or it is something that will be tested when it comes to practice, I have a way of navigating through it without delving into the details. CLE will give you a problem question. You are the debtor, you are the creditor. Do you know the grounds? A draft. Bas. Application to set aside statutory demand. But remember, we can't ignore various powers that the court may have. In fact, under your prayer as the debtor, you can say that this court has power to order an amendment because I have seen the security is with debtor, only creditor. Only creditor ndiye anataka amendment because he has undervalued a certain security. Okay, whichever the case will be, provided the court will have this power to order an amendment. Application to set aside statutory demand, the practical angle of it. Republic of Kenya, in the High Court of Kenya, 1 mark, jurisdiction. Insolvency cause number in the matter of the Insolvency Act, mark, because you know the enabling provision. And in the matter of a statutory demand issued against the application to set aside statutory demand. Take notice that the Honorable Court will be moved on this date, day of this day, by the debtor or applicant for order start 1, that the statutory demand dated this date and served upon the applicant on this date be set aside, that the cost of this application be provided for, that 3, such further and or other orders be made as the court deems fit, which application is based on the ground set out in the supporting affidavit annexed here to Form 8 and on the following grounds. The alleged debt is disputed on substantial grounds. Regulation 17, 6B. The applicant has a counterclaim or set-off or cross-demand equal to or exceeding the amount demanded. Section 17, 6. How will you know the amount is equal to or exceeding the amount demanded from the counterclaim? The facts will give you various dates. You have to compute, you do the totals. This is the minimum, so mine still exceeds yours. Good. The creditor holds security whose value equals or exceeds the debt and or the demand is defective for failure to properly set out security particulars. Okay, Regulation 17.6. So you answer the question that I wanted to see where you will make this application. So you are telling the court to use its discretion to amend, because the creditor already holds a security whose value equals or exceeds the debt if my debt was a secured debt. D. The demand is liable to be set aside on other grounds, including material defects and or abuse of the insolvency process, but these material defects should be substantive. Signature, endorsement. Okay. Haya, dated, signature. Haya, capacity umeandika. To be served upon the creditor or any other person. This is the supporting affidavit. Title capture, I refer to the title indicated in my application above, Form 7. Now this is Form 8. I, data of this, make oath and state that I am the data and applicant herein, and competent to swear this affidavit, that the statutory demand dated came into my possession on this date, and I received on this date, after being served upon me at this place by process server doing this, that annexed hereto and marked A is a true copy of the statutory demand. So now to meet the marking points, that I have filed this application within 21 days of service of the statutory demand, or within 21 days of the first advertisement of the demand on this date. Marking points, good. Now, you need now, sasa I realized you only know how to introduce a supporting affidavit juu uko na 3 marks zenye ziko kwa kichwa. But do you know these various situations that the examiner can use so that you as a data, you can extract out what you incorporate in your application. Usiende na general stories. Let us look at Regulation 17.6b. Debt disputed on substantial grounds. Utasema hivi. The alleged debt is genuinely disputed on substantial grounds for the following reasons. 1. There is no contract or goods not delivered. Defective services, wrong party, limitation, payment already made. Set out particulars clearly. Annexed hereto and marked B are supporting documents showing the dispute, namely receipts, correspondence statements, contract and delivery notes. Hiyo ni fact yenye sasa you as the data you want to set aside the statutory demand in application to Regulation 17. Another angle yenye you can counter, 1, where there is a counterclaim, set off or cross demand pursuant to Regulation 17.6a. Mimi kama data, I have a counterclaim, a set off or a cross demand against the creditor arising from a transaction this in the sum of this, which equals or exceeds the amount being demanded. These are the annexures to support. Remember, I'm including in any point, every point must have an annexure to support. Then another angle that still you can be asked, creditor holds security. So the creditor holds security over, describe the security whose value is this amount, which equals or exceeds the alleged debt. The statutory demand is defective because it fails to disclose the security, or misdescribes it, or undervalues it, or claims the wrong unsecured balance. Sasa hapa the court can exercise its discretion. Naona, if the security is undervalued, then the creditor can say, kindly, I pray that this honorable court duly amend, I might be granted leave to amend the statutory demand. How is it defective? But my statutory demand fails to disclose the security. Nina misdescribe it. So failing to disclose a security looks like a fatal angle in a view, because you don't want to say that this person has the debt that you have secured. So una feature details to the detriment of the data. So that is another angle. But we say that claims the wrong unsecured balance, we said that it is the onus of you kusema the tabulations of why you are saying is the balance is wrong, the unsecured balance is wrong. Other grounds, the demand should be set aside on other grounds, including demand not endorsed by deputy registrar, wrong form, wrong amount, insolvency used to enforce a disputed debt, defective service was observe that unless the statutory demand is set aside, the creditor will improperly invoke bankruptcy proceedings, notwithstanding the substantial dispute or counterclaim or security, and the applicant will suffer prejudice. That I pray the court sets aside the statutory demand and awards cost to the applicant. Who is the signature? Is it before a commissioner of oath? Yes, because it is a supporting affidavit and you have duly annexed some documents, so it must be commissioned. Mistakes students commonly make and courts punish. Missing the 21 deadline, they file late without seeking leave. Regulation 16.1. Okay. Failing to annex the statutory demand to the affidavit. No. Regulation 6.4c makes it mandatory. So ile affidavit una draft. That is the reason why we started na kuscoop the 3 mandatory marks. Have you annexed the statutory demand? When did you receive it? What are the grounds that you want to set aside? 3 marks mandatory. Chukua hizo. Pleading I cannot pay as a ground to set aside. Inability to pay is not a set aside ground. The grounds are in regulation 17.6. Sasa hawa ni wale students walienda na theory. These are the students who read notes blindly. You just state, hey, let me draft an application to set aside a statutory demand. Hey, kindly note, Your Honor, I'm not in a position to pay. I have debts. These are my students. These are my children. Nini? Yote ni seen by the examiner. Because I'm expecting you to set aside a statutory demand on grounds listed under Regulation 17, blah, blah, blah. Raising a mere denial instead of a substantial dispute with evidence. Court expect documents, not bare assertions. This is the reason why in your supporting affidavit, the examiner will be surprised if haoni annexure marked A, annexure marked B. No. Not addressing security properly. If there is security, you must plead valuation and how the demand breaches it. Not serving the creditor in time, ignoring the 3-day pre-hearing response timeline for the creditor, procedural sloppiness, cause adjournment, and cost. Okay, service mandatory. When debtor may make application for bankruptcy order. So now this is another concept. An application for bankruptcy order by the debtor himself, sasa. Regulation 18. Remember tumeongelea regulation tumeguza regulation, let me tusiconfuse zikuwe kwa kichwa. We started with the first application that was being brought by the creditor against the debtor, regulation 15. We went to the second application, petition. The first was a petition. The second one was an application to set aside a statutory demand, regulation 16. Then we are now doing another bankruptcy petition. By who? Is it an application? To confirm. Oh, it's a petition. Another a petition by the debtor himself. Regulation 18. So the 16, 15, 16, 18. An application for bankruptcy order by the debtor shall be made by way of a bankruptcy petition and shall be in Form 10 set out in the first schedule. So hizi forms lazima zikuwe kwa fingertips. Forms zimeanza kuwa mingi. Sasa hapa ndo student huwa na cram inapotea yote. Form 3, Form 4, Form 5, Form 9, done. Form 7, Form 8, done. Hapa tuko ingine sasa. Form 10. The petition shall be accompanied by the following documents. An affidavit to the petition which shall be in Form 8 set out in the first schedule. Statement of debtor's financial position, which shall be called a statement of affairs and shall be in Form 11 set out in the first schedule. C. Application for appointment of trustee, which shall be in Form 9 of the first schedule. So, kwanza, in both application by the creditor and the debtor, Form number 9 is constant. Okay. Form 10 is an equivalent petition in Form 3 of the creditor's petition. Hapo kwanza tumedeal nazo. Affidavit to the petition, ile ingine ni Form 4. Here we have Form 8. Okay. Another thing is that we had proof of debt in creditors. Hapa ni statement of debtor's financial position, also called statement of affairs, because you want to tell court that you cannot be able to pay. Also, before I make those comments, let us see what it entails in a statement of affairs. For the purposes of Section 32(2) of the Act, the statement of debtor's financial position is required to include the following information. So this now answers my fears. What do you include? The debtor's full name, the debtor's current address, telephone number, and any other contact detail, including mobile telephone number or an email address. If the debtor has used any other name, including any alias in the last 7 years, those other names and aliases. The data's date of birth, so an examiner anaweza kuwekea pale also known as person X. So he expects to see that you have included the alias name in the statement of debtor's financial position. Okay, the debtor's date of birth. Are you ignoring that this debtor was born on this date? Are you ignoring the particulars of his phone number? Whether the debtor is male or female, have you ignored that? The debtor's Kenya KRA personal identification number, unashindwa kwa nini examiner ameweka pale PIN number? If the debtor has a current passport, his nationality and the passport number, you have also been told by an examiner that this person is also a Nigerian. He has a passport number this. If the debtor is employed, employer's name and address, debtor's occupation, a statement of debtor's income, an itemized statement of debtor's expenses. You have been told that this person have recurring expenses every month, this amount. A statement of the partner's income. Does he have a partner? A statement of the debtor's current assets, including the inscription value, location of those assets. A statement of any assets that the debtor has disposed of in the previous 3 years. Why? To defeat execution. A statement of the debtor's liabilities, including any contingency liabilities, with the following details for each liability. Do you have any contingent liabilities? List them, the amount, whether the liability includes goods and services tax, how liability was incurred, whether the liability is secured, if the liability is secured, as description of the security, whether the liability is a preferential debt. Haya, hapo sasa vitu zimeanza kuwa technical. The priority of settlement. A statement of all financial transactions by the debtor during the previous 3 years. The debtor is required to sign and date the statement of debtor's financial position and arrange for the publication of the statement in the Kenya Gazette. The debtor shall be responsible for the cost of publishing the statement in the Gazette. Regulation 18 is the debtor-initiated bankruptcy route. A debtor can petition to be adjudged bankrupt only on inability to pay debts and must file Form 10, with Form 8 being an affidavit, a full statement of affairs, Form 11, containing the prescribed disclosures, and Form 9, a trustee appointment. The statement of affairs must be signed, dated, and published in the Kenya Gazette at the debtor's cost. Non-publication or incomplete disclosure can lead to the court declining to hear the petition or striking it out. No. So statement of affairs, marking points. Has it been signed? Good. Has it been dated? Good. Have you published it in the Kenya Gazette? The same way we are told, statutory demand, you take before the deputy registrar. Now here, have you taken the statement of affairs to be published in the Kenya Gazette? Governing rules. Debtor's petition threshold plus court powers, section 32. Debtor may apply only on inability to pay debts. It is only on inability to pay debts is where you will initiate this petition. Must file a statement of financial position with prescribed particulars. That's why I saw it fit to read through the list so that tujue ni nini inaandikwa hapo. Court may reject an incomplete statement. Debtor must publish the application or statement as required. Court may decline to hear if publication not complied with. Okay, so in your affidavit, in your statement of affairs, Form 11, you ought to disclose that you have also published the same. Regulation 18, mechanics. Petition is Form 10 of Rule 18. Must be accompanied by Form 8, an affidavit. Form 11, statement of affairs. Form 9, trustee appointment application. Minimum content for statement of affairs is expanded all the way from A to P. Statement of affairs must be signed, dated, and published in Kenya Gazette at debtor's cost. Judicial interpretation. Publication in the Kenya Gazette and statutory publication scheme is mandatory. The court may decline to hear or strike out for non-compliance. We have seen that decision. Jonathan Cheriot versus Bungoma Chemist Limited. Full candid disclosure in the statement of affairs is essential. Incomplete or unsupported disclosure can lead to dismissal, while courts sometimes allow a short window to rectify. Okay, full and candid disclosure is essential. James Maina Kabatha, 2020. So dismissed for failure to prove inability to pay and inadequate disclosure. Osman versus First Community Bank, 2022. Entry gate. Data must show inability to pay, not just inconvenience. Disclosure regime, Rule 18, forces an open book filing. Identity, income, expenses, assets, disposal, liabilities, including contingent, secured, preferential debts, and a 3-year transactional history. Creditor protection, public notice, gazette publication is to alert creditors and to prevent further credit being extended on false assumptions. You are protecting the public so that is the rationale of why we gazette. Draft and file Form 10, debtors petition. Attach affidavit to petition, statement of affairs, Form 8, Form 11, Form 9. This is the now drafting part. This is the drafting. Title sahi tuko sawa. Jurisdiction, solvency cost number. In the matter, enabling provision, Insolvency Act. In the matter of this person, debtors petition, Form 10. I, the debtor of this, lately residing at, carrying on business at. Why are you defining those details? Because they are mandatory. Having for the greater part of the past 6 months resided at and carried on business at within the jurisdiction of this court, in being unable to pay my debts, hereby petition the court that a bankruptcy order be made in respect of my estate, and that I may be adjudged a bankrupt. Signed by the debtor in my presence, witness name, address, blah blah blah. Form affidavit to the petition. Marking scheme, Form 8, good. Ile ya kwanza, Form 10, good. That I am the debtor applicant herein, competent to swear this affidavit. That I have filed the debtor's petition dated this date, seeking a bankruptcy order against my estate. That I am unable to pay my debts as and when they fall due to the following reasons. So you have to explain. Loss of income, business collapse, medical bills. I have been diagnosed with cancer. I pay 200,000 per month for medication. Judgment debts, over indebtedness. My total liabilities are approximately this amount against assets of approximately this amount. That my statement of affairs, statement of debtors' financial position is annexed hereto and marked A and sets out the full disclosure of my identity particulars, income and expenses, assets and liabilities, including secured and contingent liabilities, assets disposed of, and financial transactions for the preceding 3 years. Why? Those details are mandatory. That I have signed and dated the statement of affairs and I have arranged for its publication in the Kenya Gazette in compliance with Regulation 18.4. So this is the part that I said that you have to disclose that you have published the same. That I pray the court grants the petition and issues a bankruptcy order and appoints a trustee as per the accompanying application. So in both, to realize, the creditor was seeking the court to appoint a bankruptcy, to appoint a trustee, and in failure, he sought an insolvency, an official receiver, or an appointee of an official receiver. Is it before commission of oath? Is it dated? Is it signed by the debtor? Good. Marking points. Form 9. Application for appointment of trustee. Title tuko sawa. Application for bankruptcy trustee, Form 9. Because Form 8 was affidavit. Form 10 was the petition. Haya. How do I draft an application for appointment of trustee? Pursuant to Regulation 18, I, the debtor, do on the ground set out in the annexed affidavit, apply to the court to appoint a fit and proper person as trustee of my property in accordance with the Insolvency Act, Cap 53. Proposed trustee, tick 1, the official receiver or name of licensed insolvency practitioner, if you have one. Special directions, if any, 1. Authority to take immediate control of business and book. Any urgent preservation orders needed. You can seek preservation orders as the date appear. To be served upon, dated, have you signed, have you served upon, official receiver if application made in court. Form 11, statement of affairs. So, Republic of Kenya, title tuko sawa, statement of affairs, individual person, form 11. Now, look at how we have broken down the specific parts. You can just take out the parts huko ndani utajibu. Provide the identity and contacts details of this data. Unajaza zote, KRA PIN, kila kitu that is used to identify you, even the gender, phone, current nationality, passport number, good. Identity number, good. Now, employment or income status. Umetuambia pale umepoteza kazi. Are you employed? Are you self-employed? Are you unemployed? If employed, who is the name of your employer? We saw that. Occupation. What is your occupation? Monthly net income. Attach pay slips or bank statements where possible. Partner's income. Because we saw wanaweza uliza mpaka partner's income. Okay? Expenses. Itemize monthly expenses as follows. Food, nini zenye zina recur. Do you have contingencies? Assets. Unaona, unatoka expenses unaingia assets, current assets. Ndio hizo una list zote. Disposed assets in the last 3 years. In the last 3 years. Unaandika. Liabilities. Include contingent liabilities. Do you have a loan? Do you have tax obligations? If the loan you have, is it secured? Is it unsecured? Is it preferential? Financial transactions. All financial transactions in last 3 years attach. Material transfers, repayments, gifts, guarantees, asset sales, loan restructures, declaration. I declare that this statement of affairs is, to the best of my knowledge, a full, true, and complete statement of my financial position and transactions as required by the Insolvency Act and regulations. Have you signed? I read before a commissioner of oaths, because it is a declaration, a statement of affairs. So we need to see that you are not lying. Higher, you have not yet been through. You told us that you have published this I need to statement of financial affairs. You have duly gazetted. So you need to see a notice of publication. Okay, take notice that the data describe him. Filed a debtors petition for bankruptcy order in insolvency cost number at the High Court of Kenya at this station. The data statement of affairs has been published pursuant to regulation 18 for the insolvency regulations, dated. So you need to see a notice of publication. When is the gazette notice dated? When did you gazette? Do you have evidence to show that you duly gazetted? Mistakes to avoid. Filing Form 10 without Form 11, statement of affairs, or filing an incomplete Form 11, missing assets, disposed of, contingent liabilities, or a 3-year transactions history. You see, ignore assets, contingency liabilities, or 3-year transactions. Not publishing the statement of affairs in the Kenya Gazette, or publishing but keeping no proof of receipt or receipt. Using the wrong affidavit. For data petition, it's Form 8 attached to the petition. Don't use the creditor side verifying affidavit format. Hapo unaenda na affidavit, supporting affidavit. Is it a general affidavit? Acha ni confirm is correct. This is the application for bankruptcy trustee. Affidavit to the petition. It's just a general affidavit to the petition. The creditors ilikuwa verifying affidavit. So use the correct. In the debtors petition, it's Form 8. Under disclosing assets or recent transfers creates credibility issues, can lead to refusal of directions and later offense exposure under the Act. Math inconsistencies, assets, liabilities, totals not matching schedules, missing valuations of location, security or descriptions. Not addressing inability to pay with facts. Income versus expenses, enforcement pressure, judgments, arrears, bank statements. So don't say you are unable to pay. To what extent can you be unable to pay? You need to see. Okay. Regulation 19. Prescribed minimum value and small bankruptcy level. So, for purposes of Section 33 of the Act, The prescribed minimum value in bankruptcy is 500,000 shillings and the small bankruptcy's level is 100,000 shillings. How do courts interpret this part? Regulation 19 basically sets two money checkpoints that help the court decide what kind of bankruptcy process to use. Small bankruptcy level, where it is capped at 100,000. If the person's unsecured debts not backed by security like a logbook or land title are Kenya shillings 100,000 or less, the law treats it as a small bankruptcy situation for Section 33 purposes. Scenario: Mary owes 80,000 to a shop supplier and has no secured loans. That is within the 100,000 small bankruptcy level. The case may be handled under the small bankruptcy approach, simpler handling under Section 33 options rather than the heavier full process. Scenario B, not small debt. John owes 250,000 in unsecured loans. That is above 100,000, so it is not treated as a small bankruptcy under Section 33. When we will be analyzing the Insolvency Act, we will go directly to Section 33 so that we know if I have facts that the unsecured loan in this situation is below 100,000. Okay, so I need to know what application to go under. Let us check what we mean by prescribed minimum value of the 100,000. Okay, so the two terms, prescribed minimum value, ingine ilikuwa small bankruptcy level, 500,000. This looks at the value of what the debtor owns, their estate, property, vehicle, savings, business assets, etc. If the debtor's estate is worth 500,000 or more, the court may decide it's worth bringing in a licensed insolvency professional to assess the estate and guide a structural solution like a voluntary arrangement instead of letting the case run as a basic or automatic bankruptcy process. Unaona pale examiner amepokea facts, mtu ako worth madeni zake ni the estate is worth 700,000, then you want to force the court to run the normal automatic bankruptcy process. Did you propose to this person that they can bring in a licensed insolvency professional expert to assess the estate and guide a structural solution? Scenario C, assets are significant. Ali owes 90,000 small bankruptcy debt, but he owns a car worth 700,000. Because his estate is above or equal to 500,000, the court may consider appointing an insolvency practitioner to prepare a report and possibly steer a better solution, e.g. selling the asset properly or arranging payment to creditors. So that was deliberate. Ali owes 90,000 to fall under the small bankruptcy debt, but he owns a car worth 700,000, so that pushes him to the prescribed minimum value of 500,000. Scenario D, assets are low. Faith owes 70,000 and her total assets are only 120,000. Her debts are small and her estate is below 500,000. So the law is less likely to justify a more complex professional-led process under Section 33. The simple takeaway. 100,000 asks, is the debt small enough to be treated as a small bankruptcy case? Then 500,000 asks, are the debtor's assets big enough that the court should bring in a professional to manage or report on the situation rather than treat it as a very small case? Regulation 19 creates two money switches. Under Section 33 of the Insolvency Act, the small bankruptcy's level is 100,000, is the ceiling for debts to qualify as a small bankruptcy case. And two, the prescribed minimum value, 500,000, is the minimum estate value threshold used when the court is deciding whether to appoint an authorized insolvency practitioner to prepare a Section 34 report or supervise a voluntary arrangement instead of a full bankruptcy track. Governing rules. Section 33 of the Insolvency Act defines and uses the two thresholds. Small bankruptcy level and prescribed minimum value are amounts specified in the insolvency regulations for purposes of Section 33. The court's appointment power under Section 33 is triggered where, among other things, unsecured debts will be less than the small bankruptcies level and the bankrupt's estate will be equal to or more than the prescribed minimum value. Okay. Regulation 19 supplies the figures for Section 33. Okay. Judicial interpretation. Courts treat these figures as hard statutory thresholds when deciding whether bankruptcy framework is properly engaged and when applying the minimum value concept in bankruptcy matters. Debt meeting the statutory minimum or threshold supports issuance of bankruptcy orders where the rest of the Insolvency Act requirements are met. Court treated Regulation 19 as setting the statutory minimum benchmark reference in bankruptcy context. Threshold points are treated as statutory gateways, not discretionary powers. Okay? So, key takeaway, practical meaning and how to apply Regulation 19 correctly. Small bankruptcies level. Used to classify a bankruptcy as small for Section 33 purposes, i.e. where unsecured debts will be below 100,000 if a bankruptcy order were made. It is not the main creditor petition threshold. That is the prescribed bankruptcy level under Regulation 3 at 250, tied to Section 17. Prescribed minimum value, used to test whether the bankruptcy estate value is sufficiently material to or greater or equal to 500,000 for the court to consider appointing an authorized insolvency practitioner under Section 33, typically to prepare the Section 34 report. Common mistakes. Confusing Regulation 19 with Regulation 3. Students cite 100,000 or 500 as the creditor bankruptcy filing threshold. The creditor threshold is 250,000 via Section 17. Treating prescribed minimum value as minimum debt, then it is about estate value, not the amount owed. Hapo nataka ushike vizuri. When we are talking about prescribed minimum value, the 500,000, we are testing the estate value. It is not the amount owed. That is why I incorporated a scenario where there is an amount owed together with a prescribed minimum value a car and value the asset of a car worth 700,000. So never confuse. Ignoring that small bankruptcies level is about unsecured debts. If a bankruptcy order were made, A, classification or assessment point, not a general debt recovery minimum. Okay? So don't ignore that small bankruptcies level is about unsecured debts. Not anchoring Section 33 to Regulation 19. Okay, not anchoring Section 33. Regulation 19 only operates for purposes of Section 33. It does not replace other thresholds elsewhere in the Act or regulations. We will leave this discussion at this point. We will pick up from Section 33. Are there any procedures that we can be told to draft? Are there any operational technicalities that a student can face? Because if I dilute this content further, we will forget everything. So I'll stop the projection here. I'll save this recording and upload in YouTube. We'll meet in our second session. Thank you for your time.